Morning. Hello and welcome. If you are a student curious about how privacy laws are shaping the digital economy, or a professional navigating compliance in your industry, or a business leader responsible for safeguarding user data, this series is for you. In this video series, we'll explore India's landmark Digital Personal Data Protection Act 2023, a transformative law that defines how personal data is collected, stored, used, and protected in a digital era. But we are not just scratching the surface. This is a deep dive across 8 focused parts where we break down the impact of the DPDP Act on some of India's most data driven and compliance sensitive industry, namely the BFSI sector, where consent, risk, reporting rules are redefining how banks and insurers operate. We look at IT service industry where global delivery centers must align with both Indian laws and client expectations. We'll then look at the healthcare sector where patients' rights and sensitive data demand ironclad protection. We look at the hospitality industry, wherein managing trust, identity, and personal preferences of millions of guests is paramount. We'll then look at the educational sector, where children's data is at the center of privacy enforcement. We'll then touch base on the world of marketing and sales, where consent is now the backbone of every outreach strategy. And finally, the social media industry, navigating new restrictions around profiling, tracking, and child safety. So, whether you are preparing for compliance in your organization or simply want to stay informed, this series is designed to simplify the law, contextualize the impact, and guide you through practical next steps. So, grab a cup of coffee, stay tuned, and let's together decode the DPDP Act one sector at a time. Part 3, Digital Personal Data Protection Act, Impact on the IT Service Sector. As part of this part of the series, we will cover introduction, classification under the DPDP Act, key component requirements for IT companies, SDF specific requirement for large IT service providers, cross-border data transfer implications, overlap with existing laws and contracts, operational and business impact, compliance readiness checklist for IT companies, strategic opportunities, DPDP Act compliance checklist for the IT service act sector, and we'll have a conclusion. Why IT service sector matters? The Indian ITS sector is a major processor of personal data for global as well as domestic clients. It powers outsourced operations in BFSI, healthcare, retail, and telecom sector. It handles cross-border data from multiple jurisdictions. It hosts data centers, cloud platform, and managed services that deals with personal data at scale. As such, IT service providers are often data processors or co-data fiduciaries under the DPDP Act. Let's look at classification under DPDP Act. Data fiduciary, well, these are company decides the purpose and the means of processing. Example, we have the SaaS companies offering payroll softwares, etc. The data processor, well, it's a company processes data on behalf of a client, which is generally the case in large Indian IT companies. It works on behalf of its client. Significant data fiduciaries, well, these are entities handling large sensitive data or national impact. This also would play a role as we have large organizations in this category. Many large IT players, whether tier 1 IT firms or so on, global delivery centers and cloud infrastructure, are likely to be designated as SDFs. So, if you are a service provider in IT space and a big player, mostly you would be categorized as SDFs or a significant data fiduciary. Hence, the DPDP Act would be applicable in its full for your operations. Now, let's look at the key compliance requirement for IT companies. You would need to ensure the consent flows are honored when providing B2C SaaS or client portals. You need to encrypt data in transit and at rest. You need to have role based access and a very strong IAM control. Coming to IAM control, I have a separate video on IAM related. You can look at that and to get a perspective and what can be done in that space. But that's a separate video that's there all active. You can look at that. You would need to set up incident response aligned with DPDP timelines. You need to update your data processing agreement to include the DPDP clauses. Now you need to avoid collecting non-essential data, especially in shared platforms. Define what's essential first. Be careful when you're defining it, articulate it so that you really know what's essential and so that others can be ignored or can be dropped out. As DPDP would be very clear, when you define something as non-essential, it would have a different workflow for review against what's essential, and there would be a scrutiny on what you define as essential and non-essential. You need to implement auto deletion and backup purging workflow. This is, you do have a deletion activity, you would have a backup purging workflow, but now it need to be linked to from a DPDP perspective. You would all link to the customer trigger point. When the customer decides it needs deletion, the process should start, not wait for anyone's approval for his data. You need to have a system in place to define how would you identify a person data belongs to that person or not. The last thing you want is someone being able to delete any other person's data. So all those checks and balances would be required. If the offering apps for under 18, you need to apply strict filters and obtain parental consent with evidence that parental consent was indeed taken. You need to include complaint management features in client facing systems. These are some of the major challenges that an IT company would have to navigate while implementing the compliance requirement. Do note, while most of the process would be there, but linking it to DPDP requirement would be the major aspect of automation. Because now the control is not with you. You have the workflow, but the trigger for deletion or erasure or purging is also with the user, because his data is the one which he is interested in purging. So that interaction need to be built in. Let's look at SDF specific requirement for large IT service provider. Now, if you are classified as significant data fiduciary, there are additional duties which might be applied to you. First, you need to have a DPO, a data protection officer, located in India. You need to conduct data protection impact assessment. You need to perform regular independent audits. You need to implement a robust privacy by design practice. You need to maintain logs and traceability for decision making process. So these are applicable for those organizations which are classified as significant data fiduciaries. Let's look at the cross-border data transfer implication. Now, many IT firms host or process personal data for foreign clients using Indian cloud infrastructure or Indian client using foreign cloud service provider. Under DPDP, cross-border transfers are allowed by default. But transfers may be restricted to certain blacklisted countries by government notification. Now, IT companies who need to review their data flows, their storage zone, and ensure contract anticipate future blacklist, which means a particular group of country or a country is currently not in blacklist. And if tomorrow there is a specific country added to the blacklist, you would need to factor that in how you would move to comply with that requirement. What would be your procedure, policy, timeline? How would you ensure that it is done clean? What is the evidence that you would have? How would your baseline change? All of these need to be factored in as part of your design. So your design should be in such a way that as and when a country is added or removed from the blacklist, your operation should be automatic where possible or very clear as to how you would go about. This is something that you would need to demonstrate to the regulator when asked for. So, this cross border data transfer has serious implications, and the ownership is on you to prove it's working. Let's now look at some overlap with existing laws and contracts. Well, you have GDPR. Well, many firms already comply, leveraging existing control of DPDP readiness. You have ISO 27001. This certification supports SDP security, but more may be needed, like the consent mechanism example. That's addition to the current. You need to review your MSA, SLA, DPA for Indian regulatory references. Your MSA, SLA, DPA should be very clear how they align with what part and sections of the DPDP Act. It's not that you throw the MSA, SLA and DPA at the regulator and say, this is what we have. You should be able to show them this is the MSA and so on, and here are the sections which fits into each section of the DPS requirement applicable for your business. Let's now look at the operational and business impact. The benefits are enhanced credibility for global clients. They create a competitive edge with privacy compliant offerings, and this helps strengthen your cyber risk posture. From a challenge perspective, the PDP Act or any act when gets implemented or you want to get in compliance, It includes a high compliance cost. It's an overhead for mid-size or any firm, but it's an overhead, but that's a requirement in terms to be in the business. You need to redesign tools and workflows for consent, grievances, breach notifications. Of this, grievances and breach notification would generally be there. The challenge would be in consent and grievances. While you might also have something on grievances, but consent is potentially a new aspect that you need to factor in. You need training for your employee on privacy rule and the definition and the expectations. Let's look at your compliance readiness checklist for IT companies. The first one that is high are you should know what personal data is processed, where it is processed, and from whom you have acquired it. You need to add DPDP compliant terms in DPAs and MSAs. You need to plan early for resource hiring and process alignment. Second part is you have to build user interface, APIs, and escalation paths. You need to align with DPDP and certain timelines. You need to educate developers, HR, legal, operation on privacy by design aspects of it. Let's look at strategic opportunity. Well, it offers DPDP compliant managed services to client as value add. You can have that. Your organization can build and pitch that you are offering DPDP compliant managed services. You can build SaaS tools for privacy management, consent lifecycle, grievance redressal. These are challenges of today, and if you are into this business, these are opportunities and opportunities that you can build your businesses. You can become a privacy outsourcing partner for global SMEs targeting India. So these are some of the aspects that can help you build it. Let's now look at a checklist that we can use for different aspect of getting in line with the DPDP Act's requirement. Starting off with governance and leadership. First, appoint a privacy program owner, typically from risk, compliance, or legal team. Define a DPDP compliance roadmap approved by the executive leadership. Next is assess whether the organization qualifies as a significant data fiduciary. Then follow up by appointing a data protection officer. Once done, create a data privacy task force. You need to involve your IT, your HR, your legal, your delivery team, your security team, and your engineering team. You need to allocate budget for tools, audits, training, and legal advisory. This is your first step. Once you have done this, then we move to the aspect of data discovery, classification, and mapping. You need to conduct a personal data inventory across systems, geographies, and business. You need to tag the data type by type, which is either PII, SPI, subjects, sensitivity, and residency. Map the data flow. This is one of the most critical aspects, from collection, processing, storage, sharing, deletion, the whole 9 yards of it. Then you need to identify personal data in SaaS application, customer data warehouse, employee record, chatbot, forms, ticketing systems, etc. Then we move to the next aspect of consent and notice framework. You need to implement explicit consent collection mechanism in B2C or client facing applications. You need to provide clear privacy notice in English or relevant English Indian languages. You need to enable withdrawal of consent option. Could be web, mobile, self-service, or all the channels that you are available on, or engage with your customer. For B2B service, ensure contracts capture client's role as data fiduciaries. You need to integrate or register with the consent manager platform if handling large user base. Once you have completed these steps, you move to the next phase, which is data principles rights management. You need to first set up a rights management portal for access, correction, and deletion request. You need to authenticate identity before fulfilling the request. You need to automate workflow to notify processors or cloud vendors for data correction or deletion. You need to track and audit rights request for SLA compliance and governance. Once you cross this step, you move to data retention, erasure, and minimization aspect. In this, you first define and enforce your data retention schedule for all platforms. Then you implement data erasure routine across your database, logs, and archives. Then you need to ensure backups, cache, and replicas are included in your deletion plans. Then you embed data minimization into data collection forms and APIs. Once you have addressed these aspects, we move to security, privacy, and breach management. You need to conduct a DPDP aligned gap assessment against your existing security control. Why existing? So you don't have to reinvent the wheel. Find out what the gap is, and that's where you move. You need to update your cyber security policy to reflect DPDP breach response timelines. Then you need to align certain and DPDP obligations in breach playbooks. You need to implement encryption, data either in transit or at rest, in both aspects. You need to implement access control, whether it's RBAC or MFA, etc. You need to implement activity logging and monitoring. Then you need to run your privacy drills and breach simulations. Once you have crossed this hurdle, you move to the next aspect of third party and cloud vendor governance aspect. In this, you review and update data processing agreements with all processors and their sub-processors. This should include clauses on consent handling, data deletion upon contract end, and breach notification timelines. You need to create a vendor privacy risk scorecard. You need to conduct periodic audit or require privacy attestation. One of the most sensitive and the most difficult aspect, this third party and cloud vendor governance, and general leakages and breaches happen in this space. You can take your time, pause the screen, take the input, check against your current one, and see where the gaps are if there are. Once you cross this hurdle, you move to your software development and engineering aspects. The first is you integrate privacy by design into the SDLC pipelines. You include privacy risk evaluation in code review, feature design, UAT, and regression testing. Then you build in consent logics Data masking at UAT, auto logout session timeout, implement data access login apps with sensitive user data. Once you have achieved this or cleared this aspect, we move on to children's data handling. In this, you identify if any product handles data of minor, which is less than 18 years of age. You need to implement verifiable parental consent. Verifiable parental consent. An extremely difficult aspect currently that you need to figure out how to crack it. You need to block behavioral profiling, targeted advertising, and data transfer without explicit safeguard. All of these three need to be blocked. You need to seek exemptions only if platform is verifiably safe, defined as per the DPDP rule. Then we move on to cross-border data transfer aspect. You need to identify all cross-border workflow for personal data. You need to monitor government notification on restricted countries, the blacklist approach. You need to include transfer mechanism and safeguards in contracts and design. And where relevant, offer India-based hosting to privacy-conscious clients. The next aspect is employee and internal HR data compliance aspect. In this, you need to apply DPDP protection to employee data. You need to obtain consent for access card systems, wellness program, surveillance tool, if any. You need to enable employees to access and correct their data. You need to secure internal HRMS and personal files. The next aspect is training and organizational awareness. You need to deliver DPDP training to all employees and you have to prove that all of them were trained. You need to customize the training for developers, for support staff, for sales and contracts. Training should include privacy in induction and regular learning cycles. The next aspect is monitoring, audit, and continuous compliance. In this space, you need to maintain a DPDP compliance dashboard. You need to conduct regular internal audits of privacy controls. You need to document DPIAs, grievance redressal records, consent logs, breach investigation report. Then you also need to track updates from certain Data Protection Board of India, MITY, etc. All that is relevant. You need to track those. Let's take a sector by sector look at how the DPDP Act 2023 impacts different industries. Because compliance isn't one size fit all. I have compiled a comparative table covering BFSI, IT services, healthcare, hospitality, education, marketing and sales, and the social media industry. So let's break it down. Consent management. Well, consent is the cornerstone of DPDP Act, but its implementation varies. In BFSI, consent must be tightly managed, especially for KYC, biometrics, and financial information. In healthcare, it's even more sensitive. Patients and parents' consent is absolutely critical. For marketing and social media, consent isn't just required, it defines whether your outreach is legal or violation. When it comes to children's data, This is where the act is more stringent or most stringent. Educational institutions and social media platforms are directly in the spotlight here. Under DPDP, profiling or targeting anyone under 18 is strictly restricted. And verifiable parent consent becomes non negotiable. Do note, verifiable. The organization need to have a mechanism where it can prove that the parental consent was indeed from the parent. Next, on the data rights enablement perspective, all sectors must now empower users to access, correct, or delete their data. That means banks, schools, hospitals, hotels, and even digital marketers need process and tools to honor these rights, preferably through user friendly portals. When it comes to breach notification, every sector is now bound to notify the Data Protection Board, and in most cases, the affected individual within 72 hours of discovering a breach. In healthcare, this could be patient's record. In hospitality, it could be passport scan. Or for social media, a profile leak or consent compromise could trigger serious reputational and legal consequence. When it comes to third party or vendor risk perspective, here's where the rubber meets the road. Whether you are a bank outsourcing IT, a school using a learning app, or a marketing team working with an agency, the DPDP Act expects you to own the responsibility for your vendor's privacy posture. Data processing agreements and audits are no longer optional, they are essential. When it comes to grievance redressal, the DPDP Act mandates every organization to have a clear, accessible grievance mechanism. This might look like a chatbot, an email, or an in app feature. And it's especially critical for social platforms, hotels, and edtech apps that serves diverse digital first users. Well, likelihood of being classified as a significant data fiduciaries? Well, lastly, we assess the SDF risk across sectors. It is high for BFSI, IT, healthcare, and social media because of the sheer volume and sensitivity of data they process. For educational and hospitality, it is medium to high, especially if you are running large networks. And for marketing, if you're handling mass personalization and cross platform tracking, the risk goes up fast. So, as you can see, while the principle of the DPDP Act remains universal, the real world implication differs greatly depending on the sectors. Some industry will need to overhaul their tech infrastructure, while others will need to fix their lead generation or outreach tactics. But for all of us, it's a journey towards being more transparent, ethical, and user centric data practice. In the next part, we'll deep dive into each sector one by one. So stay tuned and don't forget to like, share, and subscribe if you are finding this series helpful. Do note this slide we will come again and again on all the modules that we are going to discuss. So, in case you have missed out or you need to have a better context, so when we look at BFSI and IT services and all the other areas, we will refresh this slide again and the context. In conclusion, for IT service providers, DPDP compliance is not just a legal requirement, It's a strategic differentiator. It builds global trust, enhances delivery maturity, and opens new market aligned with GDPR and CCPA. India's DPDP Act is a regulatory wake up call for the IT service sector. While larger firms may already be aligned to GDPR, DPDP introduces India specific duties like the language notice, grievance redress, blacklist based transfers. Firms that act early will not only avoid penalties but also win trust and grow globally. With this, we come to the end of part 3 where we looked at IT service sector impact from a DPDP Act perspective. I hope this session helped you in some way. I'd like to personally thank you for the time that you have invested. If you think this video has helped you in some way, or if you think this video could help someone, do share this with them so the benefit can be passed on. Let's see again in part 4 where I'll cover the next sector. Let's meet there. This is your host Savit Vitthal Salian, thanking you. Namaskar.